Um, Morning. We're back in Senate Judiciary. We're going to be taking up S7 and possibly voting on it. Sent out invitations to Adam McCrasson and Jamie Feehan to come by and provide any testimony if they want to. And again, this is quite similar to what's pretty much the same as what we voted out last year, which came out on a 5-0-0 vote, I believe. And yeah, so committee, any thoughts, conversations, or any changes that folks think we should make for this?
Yeah, email Bill and letting him know.
Yeah. Thank you. Senator Bowles.
So I will of course continue to support this bill as is, but I do still think it's pretty concerning to me that we haven't updated the coverage requirements. Something that I take that so I'm a little disappointed that that's been taken.
The cut, which part?
I don't remember the insurance terms, but my understanding is what is in the bill is the subrogation, but not the increase in mandatory coverage minimums.
Mm-hmm.
And, you know, given that that hasn't been updated since the 90s, I think that is problematic, but of course we'll support any movement forward that we can make.
Any other members?
Just if you could, I remember the bill from last year, obviously. Could we just quickly go over anything, if anything, that has specifically changed from the last time that we voted out?
So I know the limitations are not in there as Senator Volsky was describing. I don't believe anything else has changed compared to how we voted it out last time. And I'm going to look to Adam Brasson. You know, you might have some information. Did you want to provide a few quick clarifying points?
Adam McCrasson Group, Vermont Association for Justice. Thank you for the questions, Mayor. Might I borrow the document? And this double checking that the date for implementation was pushed out a year, which is something that the committee worked on. And I see that it is. The idea here being that, you know, you're not trying to impact, and Senator Root kind of brought this to the committee last year, any existing policies, and giving time for the insurance world to adjust their fine print and have it start going forward after everybody's current policies have kind of run out. So seeing that Ledge Council picked up on that, rest assured this is the words that left the Senate last year on the voice vote, unanimous, on this committee 5-0, and just refreshing your memory and for your benefit. And you really went pretty under the hood on auto insurance market. And you know, what we all find there is that this is very different than, for example, health insurance or much of what we know of as insurance, because it is a phenomenally for-profit driven sector. I was reminded this weekend watching the NFL games, every other ad, the auto insurance company, Senator Sears talked about that a lot, just as a way to signal they really, these major companies, Geico, take our premiums and invest them and make huge tens and tens of billions of dollars a year in profits. We embraced that scrutiny and hearings along the way. And the rest of the state house, fortunately last year, it just got caught up in end of session, falling through the cracks.
I just do want to mention, I believe that when we're taking testimony, when Jamie was here, that I brought up the opportunity for him to come back with a changes or whatever else. I'll be heard him on that. In fairness to him. So as far as
no, I was thinking of that throughout this, and I know that we just put this on the agenda literally 20 minutes ago because we had a lot more time than a lot more extra time than we thought. So I would like to provide Jamie the opportunity, provide us with any follow-up language
Just, you know, in good faith, Mr. Chair, where I know the area where, you know, their interest is against this. And then in the alternative, you get into the language, and this committee last year also double checked with Ledge Council to make sure that the language doesn't create an entitlement to your underinsured motorist coverage. You have to have the damages to warrant this. Remember, the big piece of this is going from gap to floating layer. So I bought 200, and if I have astronomical damages, I get my full 200. That would bad drivers coverage being deducted from what I'm getting. It's that simple. And you know, we were open-minded, saying, well, you know, if you have a different way to write that sentence, to put some suspenders on the belt, and we see there that you're not entitled to get more than you deserve. So, you know, we want to earn this on the merits and have all of you feel comfortable and supportive, because it is, people are suffering, and this is the spelt way to get some more coverage at the table for people.
So since we did pass this out with so much support last time around, and Jamie was also the advocate on the other side, it seems to me we could vote it out now. And then if Jamie has an amendment that we agree with, we could introduce that on the floor. So it seems kind of like 6 of one, half dozen of the other. We're early with this bill anyway, so there's no rush, and yet I don't think there would be any harm if we beat it.
Kayla, have you heard anything from James?
I did, and his response, sorry, I'm just waiting for it up. It was. He said he had nothing significant to share and that he will follow up later after I let him know the possible vote.
Okay. All right. Well, that gives me a bit more comfort in voting on this now. Any other conversation, thoughts, questions, links? Okay,
If you would entertain a motion,
I would entertain a lot.
I would move that we pass S7 out favorably.
Senator Meadows, if you can call the roll, please.
Yeah. Senator Norris.
Yes.
Senator Bihowski.
Yes.
Senator Brew.
Yes.
Senator Meadows, yes. Senator Hashim,
Yes.
5-0-0.
Who would like to report this?
Reported it last year.
I was wondering the same
They
thing.
should all be just warmed up and ready to go.
You report.
Senator Sears.
Oh,
What?
it
Happy to
was,
report it.
Well, the
unless
chair
somebody has-
reported
it was
Chair.
Senator Sears. I'd be happy to do it.
Sure. So I believe that if we were to take it up today, it would be reported on Friday. No problem if you want to take it up tomorrow, report it on Tuesday.
That might be easier.
That's fine. Great, congratulations. That's our first bill. Great.
Nice.
Well, I feel better with the opportunity of one, Jamie had nothing significant. And
Yeah.
Your idea as far as putting an amendment in, if you did come back with anything significant, so that's good. I feel better after you responded, just in all fairness.
Yep, I agree. All right. Great, still got plenty of time, so. on that note, well, thank you both for coming in on short notice too. So yesterday we had testimony from the administration about the proposed omnibus bill. And I want to try getting some general thoughts from the committee as to how we would like to proceed in addressing some of the policies that were submitted by the administration. We don't have a draft yet, although we do have the draft that was provided by the administration. I believe we may be receiving some bills that address some of these policies. So, yeah, we'll have this as more of a informal discussion amongst the committee as to generally how we'd like to proceed. You know, we spent the last couple of weeks getting introductions, getting ideas, and getting debriefed about how bail, digital release, and pre-trial detention work. Heard from the commissioner of DOC. So we'll just open it up now, and then we can find a direction we want to do. Senator Ruth.
Well, it seems like the core of what the governor's interested in is raise the age. And I know you had been in talks with Chair Lamond about that. And also with expungement and sealings. And so I suppose in terms of raise the age, if we go at it in a formal way, we'll kind of get to where we got last time, which is deadlock. So I would be interested in I'm not interested personally in repealing raise the age, but I am wondering if there are proposals on the table from the House or elsewhere to achieve some kind of middle ground with it, which, given the realities of where we are now, seems like probably the way to go. So I'm not sure what you're thinking, Mr. Chair, about raise the age. Is there another option besides repeal that you're considering?
I would say, I mean, yeah, in my talks with the chair of the House committee, my sense is they're going to arrive in much the same place as we were last year, which is to not repeal it, but to once again delay raising the age. From what I recall, the testimony we got last year, the addition of 19-year-olds did not cause a substantial impact on the workload. However, there was concern raised about adding 20-year-olds to it, and that would have an impact on the workload. That's as best as I can remember from the testimony. If I'm wrong, I'm sure I'll be corrected, but yeah, that's my initial vision. I take people at their word when they testify that, adding more to the workload at the moment is something that's going to work for them. I take that same, I hold that same approach when it comes to the Department of Corrections. And we heard from the commissioner that there's 130%, they're at 130% capacity in our jails, and we're sending people out of state. I've seen a lot of correspondence from COs who are struggling immensely with how things are going in the jails. So those are just some initial thoughts. Senator Volsky.
Yeah, I'm Chair Senator Burns' non-interest with repealing raise the age, and I actually have concern with delaying raise the age. We saw from the Columbia report that it does exactly what it's intended to do, which is ease the burdens on the system, increase public safety in our communities by giving young people the support they need to not further engage in the criminal justice system, which is sort of a pressure release. Like, at some point we have to do something different if we expect something to change, and continuing to do the same thing and expecting different results is, I think Einstein said that was the definition of insanity. And so there's a space for me that says, we know this works. The Columbia research shows this works. Other states are starting to implement this because they have seen it works. And so to continue to not do it is a disservice to our young people, to our communities. If we're truly committed to public safety, we have to do what works. And what we know is that by providing these interventions outside of the criminal justice system, young people are less likely to spend a lifetime in the criminal justice system, which is, again, better for them, better for public safety, and economically better because of the cost of the incarcerative system. So if we don't want 138% in our carceral system, we've got to do something to get people out of it. So I don't even support delaying it again.
Yeah, no, I would say that that's roughly where I am too, with the understanding that sometimes you have to compromise. And so I'm open to the idea of a delay as opposed to repeal. But frankly, for 3 years, they came in and told us that they were committed to the policy. They just didn't have the resources to staff. Now they want to repeal the policy and talk about it being, Jay was very unvarnished in how she described the thinking behind it. So it sort of leads me to believe that they never really wanted to have it become current practice and we're slow walking. Now it's just openly asking for repeal. So had we had reports that showed it was not achieving its objectives, or it was too expensive, or it was straining the system in some way, that's not the report that we got. The report we got, the comprehensive report, was pretty, I thought, it wasn't rosy, but it was what you want in a positive report about policy that you passed. It showed that we were positively affecting the system and those individuals. So, like I say, I go back to, and I think this is going to be true for expungement and sealing as well. And that is compromise, probably pre-worked out by chairs of the committee and then brought to us to kick around. But we've deadlocked on both of these things for years now, 3 years or 4 years. So I agree with Senator Mahowski. Do we do the same thing, or is there a way to jumpstart this policy, to jumpstart moving to a single track of sealing by just taking a different approach? I can't say what it is, but
I'd be really curious to hear so we asked for some reporting on what measures were being taken to actually build the capacity to do this. So I'd be very interested to hear from them as to what they've done.
right.
And my understanding on this particular issue is if we do nothing, we are doing something different than what we've done every other time. And so this is very rare to come out of my mouth, but in this moment, I'm actually most supportive of doing nothing.
Because it would automatically.
Because it would automatically move it forward. And I don't feel like we are negotiating in good faith, to your point, that we had this sort of repeated repeal or delay, repeal. And that doesn't feel like a good faith negotiation to me. And I generally don't like to enter into negotiations that have been proven to not necessarily be in good faith.
Senator Maddox.
How many other states have the same raise the age 19 to 20-year-olds in family court versus?
I'm not sure. I don't know.
Pretty sure it's zero.
I know many states are working on it. I actually had a meeting with R Street around this issue and others a couple of weeks ago. And so a bunch of states have looked at the data from Vermont and said, hey, this is the thing to do. We should move forward. It's kind of a pilot here.
Yeah, because over the years, I've always struggled with getting the argument and having to raise the age on something like tobacco use, raise the age from 18 to 21. Person's brain isn't developed enough. Lowering the age of voting, make the same argument. A person's brain is developed enough so they can vote at 16. And I have a really hard time always raising the age, lowering the age, and always making the same exact argument for doing so. And I've seen it, plenty of times over the past years that I've been here. So I really want to understand what this, including these 19 and 20-year-olds in the family court, because, you hear the things about exploiting these 19, 20-year-olds because they won't be tried as an adult. So that's a worry that I have. And then also just the fact that having many different ages of what we constitute as an adult depends on what we're talking about, but still use the same argument.
One of the things for me that has always pushed me in this direction is the world we live in now in terms of the internet. So family court sealed for these you know, if they are on the juvenile track, their records are sealed. And if they're not, it's, you know, it's out on the internet and it affects the rest of their life. So that was always a piece for me that if it wouldn't overstrain the system, if it wouldn't result in, you know, you hear these anecdotal stories about gangs pressuring 18 or 19-year-olds to commit the crimes so that they will have an easier track if they get caught. I've never seen real hard data on that piece. We have seen hard data on the first phase of this, which was the 18-year-olds. And so, yeah, but you know, the hard reality is you have a governor now wants to repeal this program, and you have an agency and a department that are not, you know, clearly not behind it. So that's not a, you know, it's very tough to force an administration to do something that they don't want to do. So I would love to work out an understanding with them. If it was a matter of resources, if it was a matter of something else, but it seems now like it's in a more just ideological difference. So it might be hard to get to a compromise.
Yeah, one thing I can say is, you know, the data, I don't think the data will exist because of the confidentiality that exists. But yeah, I can just say generally, as a practitioner myself, it is something that I see younger folks being used or exploited for some of these offenses that we have on the books. So, but that's just anecdotal.
Do we have data on like what this population, kind of what their encounters are with law enforcement in 19 to 20? Do we have that data? Like, is it a big population? Is it onesie twosies?
Yeah, I'm not sure. Perhaps we have that data. I bet. Yeah, I think that would be a good question for the state's attorney. You can probably get that from Tim.
And just in general, we don't have big populations for anything. Like,
Right.
I'm always amazed, like when we were talking about getting rid of life without parole, we were talking about like 8 people who are, you know, incarcerated without the possibility of parole, and they all committed, you know, and were convicted of kind of egregious offenses. But, you know, imagine if you're in California or Massachusetts, you're talking about, you know, yeah, probably. So, but I'm sure they could get us the universe or the breakdown by area of crime.
And we'll all, I mean, I was looking at the House committee's agenda. I mean, they've, for the last month, it's been all raise the age testimony. So I'm sure we'll be getting lots and lots of data, but it is good to just prep our brains for this.
Yeah.
Set of hosts.
To answer your question, I did a quick research and it looks like the current states that include 18 and or 19-year-olds are Vermont, Michigan, and New York, and Connecticut, Missouri, and North Carolina are on the path to implementation. So they're doing what we did, which is a year by year bringing in new ages. So there are some states that are doing it or in process of doing it. And I also think one of the really important pieces of data to show is that people under the age of 25 who are brought into the criminal justice system as opposed to the juvenile justice system are 34 times more likely to recidivate than they are being treated in the juvenile justice system.
Now, is that because they're in the juvenile justice system, or is that just the nature of the person? Or
I'm not sure what you mean.
creating a crime or getting a crime, yeah.
Well, I mean, I think when you look at data like that, when you look at it at juveniles treated in the adults or young emerging adults, that is the generalized language, emerging adults treated in the criminal justice system versus the juvenile justice system being 34 times more likely to recidivate. It's pretty astounding data to show it's not an individual issue. It's a systemic issue. It's you know, backed up by the brain science and the ability to navigate hot cognition and the need for those support services.
Yeah, that report that came back, I'm just remembering, maybe could we have the was it the crime?
I think it was the crime research group that came in.
Could we have them come back?
Or was it, yeah. I mean, we'll be taking a whole lot of testimony once the House sends us their bill.
Because I'm
on
remembering
this
her
topic.
presentation and she was very upbeat, going through the data. And again, it's, data isn't always the only thing that passes a bill or prevents a bill. And I know the public safety sentiment is very strong and, it's easy to hear that any piece of criminal justice reform is going to make things worse. But to Senator Vahosky's point, that report seemed to suggest we were making things better. So, it's an uphill political push, I think, but I'm more comfortable pushing if we go back through that data and see what, to the extent we have some scientific approach to it and see what that says.
Yeah, no, and Senator Ruth, I absolutely respect, understand, and agree with, the concerns around public safety. I think it's really important that we do look at the data as to what is working. And I think it was 27.
Yeah.
People were treated under this youthful offender statute in 2024. I think that's what the judiciary's data showed, but I am trying to dig it out from a week or so ago. And if 27 people are 34 times less likely to recidivate, we have made a significant impact in public safety.
Okay. Yeah, and some of this, the real issue was, with the administration, especially last year, the year before too, when I was questioning them when they were testifying, it seemed to be relatively obvious that they no longer supported the program and were just hoping to get the delay. And that's not going to work for anybody either, a kind of forced or half-hearted implementation. So it's a little murky, but I do believe between you and Representative Boland and the work in this committee and the work in that committee, we can maybe get to a place that's less unsatisfying to everyone. I'll put it that way.
What was it Senator Sears used to say if about everybody being a little disappointed in a bill, then it means everybody's I can't remember the exact shape.
Yeah, said you fit the sweet spot.
Yeah, something like that.
I don't know if I agree with that, but
Yeah.
we do pass things that everybody likes, like the pension deal that we came to. That's the only veto override I've ever seen that was unanimous. Like House, Senate, all three parties. That was historic.
I believe that was the only unanimous veto override in Vermont history.
I mean, it's hard to even imagine a subject where everybody would agree, but.
So you see, I did reach across the aisle.
Yes, you
Okay.
did. That's what everybody says. Bob Norris made that happen.
Oh, I know, I hear it all the time at home. So if I might,
They call you Bob Norris at home? Do they call you Bob Norris at home?
well, they don't call me like the So, listen, I wasn't here when you all passed this to me.
Yeah,
Okay, and I realized the governor was on board with it at that particular point in time. Even though he was in law enforcement, I was not, okay? So that's the one time I was gonna go against the governor, okay? But I obviously with this latest override, we're doing it more than once. But I think more importantly is how you phrase this, our children, our 19, these are young adults in my mind. They know the difference between right and wrong. And that's all there is to it. I don't know what we hope to accomplish, and no other state has implemented this. They're looking at it, such as Senator Bosky has said. I don't know where this data all comes from because no other state has implemented this as of yet. They're basing this off of what I don't know. But the governor came forward. He said, listen, I erred. I mean, basically, okay, I was hasty in my decision. I made a mistake. I think the human factor comes into play there, whether or not you disagree or agree with his administration. That has nothing to do with this whatsoever. I'm not saying that I don't remain open-minded about this, but I have to be convinced just the other way, as you do, as to this is something that's beneficial for our constituents and those individuals, because I believe we still have the ability under youthful offender status to states are to petition these individuals to go back to family court, right? Am I wrong in that respect?
Yeah,
You're not wrong.
it takes a while, and to my earlier point about, people's information going out on the internet, it gets treated differently until it is, and, treated as due point.
But I guess you'd have to show me that the present mechanism is broken at the time and place. Okay, we have the ability to send them to family court. And they're the ones dealing with it. The defense attorneys, the state's attorney, they're the ones dealing with it. So I just don't want to be hastily in our decision as to which direction we go in here.
I mean, there's 2 points I'll say to that, and then Senator Wachowski. You know, the mechanism to do that, you know, it's, you know, one of the things that we keep hearing about, you know, is the backlog, the amount of work that the attorneys are doing. And, you know, after this last year, I can tell you that the amount of administrative work and motions and, you know, how you move one case to another docket among the hundreds and hundreds of cases that are years old is extremely time consuming. And so, you know, when things become more streamlined and automated, that's extremely helpful. So that's one point. The other point that was brought up was about public accountability in terms of, I believe it was the AG's office, I think, that mentioned it, which, you know, having the public have information about who is committing what crime and what is happening with that case. I mean, you know, there's a reason that courts are public, the criminal court is public, there's a reason that anybody can show up and watch a proceeding, whether the person is 20 years old or 60 years old. And it provides that community with the opportunity to see what's happening when it comes to how a government is choosing to hold somebody accountable or not hold accountable based on how the case proceeds. So just 2 interesting points to consider. Senator Wachowski.
I just wanted to, again, highlight the brain science. Yes, when someone is sitting in a room having a measured conversation without pressure, a 19, 20, 21, 22, someone under the age of 25 is perfectly capable to say this is right and this is wrong. The last part of the brain to develop is the prefrontal cortex, which deals with thought cognition. So when you're under pressure, there's a lot going on. You just make a decision and it is rash because that part of the brain is not fully developed, generally speaking, to about 25. And so there is a difference between sitting and having a conversation or making the decision casually to vote for someone than there is in stressful situations. That is the last part of the brain to develop. And so that is where the brain science really shows that actually, no, people under the age of 25 generally are not capable in those really stressful spaces of thinking through the consequences and long-term impacts of their actions. And further, that they are most receptive to rehabilitation and most influenced by trauma. And I don't think we can argue that the carceral system can be pretty traumatic and is not rehabilitative. And so we are doing a disservice to the public safety of our communities by forcing people into a system that is more likely to make them lifetime criminals.
Did we get, I seem to forget, did we get an opinion or a ruling from the AG's office as to what their stance was on this the last time?
We will.
We will. We
Last time, I
didn't-
can't remember what it was last time, but I feel like they testified. I just can't remember what their position was on that.
Well, listen, I mean, you know, Senator Volsky, you know, she stated generally speaking, the frontal cortex is not fully developed. And I think we all know where we stand on this. I'd like to remain open-minded about it. But I'm not ingrained in stone here, but I guess I am to the point where you'd have to convince me that it is beneficial.
Yeah, no,
That's where I am with this.
and that as it should be. Senator Hashim talked about taking the agency, the administration at their word. I'm happy to do that, that they don't believe they have the resources. But we asked them twice, when we made the delays, to say, okay, you don't have the resources, how will you get them? Will the government put it in as recommend? Will you move resources internally, to do that? So, maybe back to Senator Bohowski's point, having them in and asking them, what have you done? That if nothing else, that will tell us whether they're making, good faith efforts to get somewhere with the. But at the end of the day, it's a reality that they have staffing concerns, resource concerns. So we need to dig into that a little more. And it depends very much what the House is gonna do, because, you know, this is the reverse of the normal situation. If we don't act, something goes into effect. And so it matters whether they're on track to produce something or.
Right. Or perhaps they'll send us a perfect bill that we all agree on.
That'd be great.
That'd be a first. I mean. So the senator here might say he's right on pins and needles waiting for that bill to come from the House, okay? But I think in reference to what you were saying, you know, we talked about disservice, whatever else. Well, the administration, I don't know what they're doing reference to this, but I heard from the laborers, I heard from people, professionals on the ground, whatever else. To put somebody, whether it's their age, whatever, into a program where it would almost be a disservice, I feel, to them. In fact, they didn't have the resources to deal with that particular situation. And if we're concerned about that, then let's look at all aspects of it.
Sealing and expungement. Okay, we're gonna be spending a lot of time tomorrow talking about that, but just as we get ready for tomorrow's conversation, it's gonna be a longer, I mean, we're gonna be getting a lot of testimony. It's gonna be one of our bigger bills that we work on. Thoughts on what we've heard so far and how we want to proceed potentially.
So the piece that bothers me the most is giving access to OPR, Office of Professional Regulation. So these people committed a crime, then they have to serve the sentence, then they have to wait a certain statutory period. And so we're talking 10, 12 years since they committed that crime. We've said that the crime fits into a category that we think should be expungible, right? Now we're gonna, if it's expungible and they get it erased completely, it can never affect their job seeking. You know what I mean? They're never gonna have an employer say, you can't get this job because you committed that crime. That's the way the law is right now. They can get it fully expunged. But if we go to a single track of sealing and we say that the Office of Professional Regulation has access to that, along with all of these other agencies and actors, we are continuing a situation where their employment opportunities are always going to be affected until that additional 10 years runs. And then nobody has the supersede. I mean, so to me, it's just overkill to ask somebody to serve their whole sentence, wait a statutory period, then wait another 10 years. In other words, increase the statutory period by an additional 10 years, and then say, at that point, 25 years after we've committed one of these, you know, offenses that we agree should be expungible. It just seems at that point like you're not doing what you set out to do, which is return them to a place in society where they're able to make a living and get past the mistake. So I'm all for the single track. It's costing us way too much money to expunge, contributing to the backlog. But at the end of the day, they've just larded it up with so many people who have access that you can't even call it sealing. It's like Swiss cheese at that point.
I agree with that. I mean, I feel like, yeah, the part of the purpose of the bill is, you know, if somebody has been on a good track for 10 or 15 years, and you know, they haven't had, you know, continual run-ins and so on, that they can go get that job that keeps them out of poverty, that keeps them, you know, on a good track in life. And And so, looking at it with just that lens, I don't see how that is something that, is impacting public safety. I do see how prohibiting access, for state's attorneys for law enforcement purposes, could impact that. So that's, that's all to say that I generally agree with that idea. Yeah. Is that opposed?
I reluctantly support a single track. I generally struggle with the idea of taking things away from people that they've come to expect, but I do think that Senator Burris and your point, Senator Sheehan, the scope of who can access it is way too broad. I do have still sort of significant resistance to only sealing for things that are no longer crimes. I do actually think that with the exception of the person who, because I do hear your point about the person who was involved in that sort of state sanctioned whatever, should have access to it, but I don't think anyone else should have access to a record for something that is no longer a crime.
Yeah, I was thinking about that the other day too. I think that, and I'm just gonna go back to that same annoying talking point that I repeat all the time, which is if government's taking action against a person, it's gotta be documented. But if that person is the one with the records, that I think that makes sense. That's a workaround. But actually, yeah, did you have a follow?
I did. I wanted to be clear that I have actually come around in my thinking to agree with you that leaving the record intact is valid, but only, literally the only person that can access it being the person for whom.
Yeah, if it's no longer a crime.
If it's no longer a crime.
Yeah.
We're not a judge.
Why?
Well, I'm just thinking, one of the things we talked about originally with Senator Sears was that these things would be sealed, but people would have to go to a judge to grant access.
In the instance where it's no longer a crime, I don't actually agree with anybody ever being able to have access except the person for whom the record pertains. I think there are some of the places in here where I could get on board with sealing and a judge being able to grant access in certain circumstances if that's still a crime. But if it's not a crime, then
Yeah.
If I did the exact same thing today, there would be no record. So I just don't think that there's any valid reason that anyone should have access to that except for the person who was subject.
Yeah, so that would be expunged in effect.
In effect, because initially what I had said, last week was that should absolutely be expunged, but Senator Sheen raised a point that I gave a lot of thought to and came to decide that I agreed with, that person should have access should they want it.
So does that include those individuals who are gathering statistics and so on and so forth also? Because you said one, just the person who's record existed. But we made it.
I think there is a way for them to still, I asked that same question, I think a week or two ago when we first talked about this bill, and I don't remember the details, but my understanding is there is still a way for somebody like the crime research group to get the data without any identifying information, to just say, yes, in such and such year, a dozen people were charged with this crime that is no longer a crime, but they don't have any other information as to who they
No
are.
names, no.
Yeah.
There's a lot of decisions that have to be made on this. Particularly an expungement bill. You may find this, I like the one track system here. I'm not sure as to just how many misdemeanors may or may not be included in this, but having said this, I'm still trying to wrap my head around why a patrol law enforcement officer needs to have access while he or she may be heading to a complaint. I know it comes as a surprise.
That is
I'm trying to, and I'm not saying they don't, but they need to convince me that they do. I can understand judicial review. I can understand, because bank and insurance wants to get into it. Everybody wants to get into this. And I think there should be a funnel where they have to not just have to give them complete access to this, whether it's judicial review, whether it's office of professional regulations that they all go through them. I don't know, but I don't think that we should open this up so that a bevy of individuals can have access to these records.
Yeah, I agree with that. I have some thoughts on it. I mean, like if you're roadside doing a DUI, you're gonna get the background put into the case, seeing that somebody had an expunged petty larceny from 15 years ago, it isn't gonna make a difference in that investigation, in my opinion. If you're doing a cold, if you're trying to resolve a cold case that's 20 or 30 years old and somehow the breadcrumbs lead you to have a idea that there might be a charge or a conviction from 20 or 30 years prior that might have some additional helpful information, then I think law enforcement will go to get the permission and explain, as they do with many other things, that, here's why we need access to this information. And then the judge can, or then, they can petition the judge to get that.
What about the situation where I'm looking at the timelines here as far as first no DOI, DO1, DOI2, and then third conviction to felony. How much access would they need in doing their paperwork? I'm looking at the years involved in this. To charge them with like DOI2 or DOI3.
Predicate offense.
Right.
Yeah.
I think I asked that question. I mean,
Yeah.
How many years?
will be available for law enforcement.
Right.
Doing a
Yeah.
29C or a records check on.
I can't remember the specifics for that, but it took a lot of finagling to get to a place where it apparently made sense. I just can't remember the details off the top of my head, but that is,
It's a rare exception, I think.
yeah. And I think also predicate offenses generally can't be expunged except for some certain circumstances. I don't want to give incorrect information. I just can't remember off the top of my head. There are predicate offenses that can be expunged if you take a deferred sentence. But that has to be, so the court, at a sentencing, the judge can't say, but depending on what the offense is, there are certain offenses that can't be expunged in a deferred sentence, but if the state's attorney allows a certain offense, like a listed offense, for example, to be included in a deferred sentence, then it can be expunged upon the completion of the deferred sentence. So that's my understanding of it. I mean, we'll be having the state's attorneys in tomorrow.
Yeah, I mean, and they would still have the ability to simply say, well, no, this is going to be DUI2 or DUI3, as long as they still have access to. But my question is, at what point in time does that go away?
Right.
Yeah.
Okay.
Yeah, and then that's a question.
Yeah, and that's a fair point. I agree with Senator Norris. The other than OPR, the other piece that concerns me is the roadside stop piece. In other words, situations where somebody's being quickly prejudiced against the person because they see this piece of information from 10 years ago or 15 years ago that no longer really has an impact, because right now it would be expunged, it would be invisible, literally, to everyone. So I just think we have to be really careful swapping that out for something that leads to a worse reality for people who committed crimes that we agree should be expungible and who have done the time that they were required to do, and then they've gone through the statutory period. Just seems super unfair to change the law now so that those people are subject to a roadside stop, to having to quickly have access to that, or they go to get a license, as a whatever, and they get denied the license because of it.
Senator Wilson.
Your point, Senator Burris, I agree with what you're saying. And one of the things I find myself regularly counseling people on in my practice is the impacts of our own human behavior. When we expect something to go a certain way, we often act in a way that helps it to go that way. And so if you're going in with that prejudice, things can escalate, and it's not unique to any one type of person. It's just what we do. If I come into a conversation and I expect it's going to go badly, my guard's going to be up. I'm going to react. I'm going to engage in a way that is more likely to make that go badly, because the person I'm engaging with is like, hey, why are you so why are you acting that way?
Are you acting as though I'm gonna do something wrong?
Exactly. And so I want to make sure we're looking at the data and the science to see when that chance of recidivism drops significantly so that someone is no more a danger to society than someone who's never committed a crime, and use that to inform that time frame. But I agree that there are just that I understand the importance, like the burden of the two-track system, but I don't want people to lose the protection of expungement in terms of both public safety and an individual.
And, you know, to go back to things that automatically happen if we do nothing. Similar instance here, this has crashed and burned 3 times. And in my opinion, it's because the administration has sought such broad access. Senator Sears tried to reach compromise with them and couldn't. And then they crash and burn and they're left with expungement, which is 100% of what they don't want. So I've been a little amused at the administration's inability to see if they don't meet our concerns, we'll leave expungement in place, which is costing, you know, huge amounts of money to the system and time to the system, resources. So we're saying we want to meet you halfway, but you know, the access for OPR, the access for DCF, the access for roadside stops, you know, that's what's hanging this up. If they would move off of that, I think pretty quickly we'd hit a place where we could all agree.
Yeah, the OPR stuff, it doesn't make sense to me as to why we need, you know, why somebody's trying to get a job 15 years later.
Right.
You know, the other piece I wanted to also mention, you touched on it briefly regarding the workload that this imposes on court staff to actually go through this and literally delete everything and, you know, go through each record. It takes a lot of time, and, you know, based on what we've heard plenty of times without the backlog, I feel like doing what we can to reduce the administrative workload in such a way that it doesn't weaken the efficiency or, you know, the proper correct completion of the work. I think that's an important thing to look at as well. You know, and also on the other hand, you know, when we're talking about giving opportunity to the state's attorney to, you know, access records for legitimate law enforcement purposes, whether it's to resolve major, you know, violent felony or a cold case. You know, there's also the defense side of things, which I think I mentioned this already, but one of the things that I heard the most about from defense attorneys is that the current system that we have needs to be changed because it's extremely problematic for a variety of reasons. You know, for example, when I started off, you know, I was trying to figure out, you know, how to access different motions and different cases in the past, see, all right, you know, what works, whereas, you know, what legal research can I do to figure out how to help my client here? And there were so many times where I couldn't find anything. And then I'd reach out to other attorneys and say, hey, I heard you worked on a case, you know, however many number of years ago. Can I get your old motion to figure out, you know, how to do mine? And they would say it's expunged. You're not going to get it. And so that's a little frustrating, but you know, that's a smaller nuance and much bigger picture. You know, there's other pieces as to, you know, defendants realizing 10 or 15 years later that perhaps they had ineffective counsel. You know, their defense attorney just wasn't doing the right job, and they realized that they had a material impact because of that, a negative material impact. There could be instances where they realize 10 or 15 years later that the prosecutor was corrupt or that law enforcement mishandled their case, and they could be, and they could be seeking that information about their old case just to try to, I'm losing my voice here, so I'll just pass it to Senator Hosky.
Well, so I want to respond to that. So this is sort of, I think, some of the conversation I know I've had both when I was in the House and in the Senate last year around switching for ease of workload sake to a one-track system, but a system that would provide what I think you previously called like sort of de facto expungement. It would not provide access to anyone except the defendants. Because I think in all the instances you name, if the person who was charged with the crime still had access, they could give it to their attorney. They could access it and say, oh, hey, I want to bring this forward because I had ineffective counsel or prosecutorial misconduct. And so, you know, the sort of space that I sit in is moving to a one-track system for the workload's sake makes sense, but anything that is expungible now should be under that same protection that the person who has access is the person for whom the record belongs. And then it creates the same benefits and protections as the expungement system while building the workload ease of a one-track system. Like I'm worried about switching to a one-track system under the idea that it's easier, but it's also actually taking away that privacy and protection.
I mean, what if the only people who can access offenses that are currently expungible, and if hypothetically we were to move into this one-track ceiling system, if the only people who can access it are state's attorneys for legitimate law enforcement purposes or defense attorneys, I'd have to figure out how to word why they would want to access it. What negative impact could that have on the defendant?
So I guess the space that I'm standing now is today, if I have an expungible defense and I get that expunged, it's gone. If we're moving to a one-track system, and the reason we're stating that we're doing that is to streamline the workload, I should not now suddenly have more people have access to the record that today would be completely gone.
I think streamlining the workload is one piece of it, one of multiple pieces, at least in my opinion. It's one of multiple pieces. I think there are other aspects to it as well, some of which have already been outlined.
And I see what you're saying about someone having access to their own records and being the only person, but it would be an odd situation, I think, if the state were in the business of preserving records that judges couldn't order access to. Because maybe I'm wrong, but it seems like judges always have the ability, you know, if law enforcement came to them and said, we think there's a sealed record, there's a, you know, danger to this individual, we need to get into that. It seems like the judge could then order access to the record. Or am I wrong about that?
That I don't know off the top of my head.
I mean, I guess if you bound the judiciary and you said, you know, you can get into it. Personally, I like thinking of it the opposite, that, you know, originally Senator Sears was pursuing a compromise where a judge would control access and people had to make an argument to the judge that they needed access. So a state's attorney had to make a motion to the judge. I like that, but I can go as far as saying state's attorneys and defense attorneys can have access to it and a judge can have access to it. But for me, that would be where it would stop.
Yeah.
And like Bob, I'd have to be convinced that anybody else needs it. And that their need overrules what they're giving up when they give up an expungement procedure.
I think on following that, and this is a very specific circumstance, I think, but you know, in the instance that we're talking about, somebody realizes 10 or 15 years later that they were prosecuted by a corrupt prosecutor or their defense counsel was ineffective, their new attorney down the road would want to have access to all the other cases that prosecutor may or may not have prosecuted improperly, or all the other cases that the police officer didn't investigate properly, or all the other cases that the prior defense attorney just didn't do the work on, which resulted in other people being, you know, unjustly sentenced. So, Senator Bozeman.
Yeah, no, I'm appreciating the challenge to sort of my thought that I'm not totally convinced, but I see your point. And, you know, as you started down that path, I still felt like the person having access to it was the picture with the, but that broader picture. Like, I think this is worth conversation about where it makes sense, but I do think it's a just the individual who currently would have expungement is not voluntarily giving up expungement. We would be forcing them to. And so I want to be really careful about how much they lose in that process.
Wait, say the last sentence again.
So Senator Baruch had said, you know, we would want to be careful about, you know, to think about what a person is giving up with giving up expungement. They're not deciding as an individual, like, oh, it's fine, I don't want it. We are deciding for them. And so I think we have an obligation to be really careful about how we thread that as we take away a protection people currently have.
I just had a question for you.
Yeah.
Defense attorneys and state's attorneys now, if the state's attorney has access to the records during a case, they have to go back to discovery, so anything they have is available to defense attorneys, correct? But if a defense attorney goes in, said, I want access to this case, do they have the same obligation to give that information to the state's attorney
For a sealed case?
for a sealed case? I'm just trying to cut to the
Yeah.
case of, okay, upon request from the defense attorney to the state's attorney, they can ask for access to a sealed record, and the court decides to give them that. And the state's attorney has it and the defense attorney has it because of discovery provision placed in the law.
I believe so. I think the issue is with expungement, where the record doesn't exist anymore, and the defense attorney, in doing their job, goes to the state's attorney and they say, hey, I want to get the discovery from this old case that this officer investigated because I think there's a pattern of dishonesty or a pattern of misconduct. Not trying to throw, well, anyways. So, but then the state's attorney will say that record doesn't exist. And the defense attorney will say, well, I'm pretty sure it does because, you know, I'm representing this person and I've been looking at all the other cases that have been, you know, interconnected with it. And, you know, here's the docket number. And you know, the state's attorney still has to say no such record exists. And then because it's been expunged.
Okay, we're trying to get away from that process.
Yes.
Who keeps those records actually? Is that something that VCIC keeps or is it kept at?
I think in part VCIC and then in part the court itself.
Not the state's attorney's office, but the court.
I believe so. The state's attorney will keep records. I mean, this, you know, I don't want to speak for particular stakeholders. I know that they'll be testifying tomorrow, but I mean, they keep certain records as well. The specifics of it, I don't know off the top of my head. Yeah. Sorry, those.
So I have two questions. One of them is for you, and I think you'll know the answer, and one is kind of a broader philosophical question. And so in an instance like you're describing where we've moved to a one-track system, the defense attorney requests records because they believe there was prosecutorial misconduct. Assuming like there's an assumption sort of that there would be something to be done and a case might be brought against that prosecutor, at which point they become the defendant and all those records are available in discovery, yes?
It would more so, I mean, in this hypothetical, it wouldn't. I guess it would depend
Okay,
on what the prosecutor actually did and if the person is suing the state or if it was so bad that they get through the immunity and can go personally after the prosecutor.
okay.
I do know the answer and it depends.
Of course it is. The law is often about as clear as mud. My other question, so currently, if you've had a record expunged and you are stopped at traffic stop, you can, and they ask you, you know, do you have a criminal record? You can say no. The same is true of an employer. Employer asks you, do you have a criminal record? They can say no. If we move to a sealing system and a bunch of different people have access, who does the person have to say yes to versus no to? Is it that you can say yes to an employer, but if you get pulled over, you have to know that you have to say yes, you do have a criminal? Do you see that confusion that could
Well,
create?
you can answer the same way. Well, go ahead.
I think that when you get to the super sealing phase where it's just the state's attorney, just the defender can have access to it. then I think that you should be allowed to say, no, I have no criminal record without any repercussions. That's after a certain timeline. But I think we have to figure out what, who has access to what during that non-super sealing period, which is what I think the prior 10 years.
It just seems to me that it would create an incredible amount of confusion if you have to tell an individual, well, these people you can tell that you don't have a criminal record, and these people you have to tell you do have a criminal record. And in these circumstances, do you see what it like the confusion that creates? I certainly know of at least one individual who had a record expunged, but it hadn't properly been expunged, got pulled over, said, nope, don't have a criminal record. And the police officer responded back, are you sure about that? And they had to call their defense attorney and say they shouldn't have access to this record. What's going on?
Yeah.
And so I worry about the confusion for a layperson that this sort of we've taken away the multi-track system behind the scenes, but created one for someone who now has much less ability and understanding to navigate.
When I look at the multi-track system we have now, and I'm trying to explain expungement and sealing to people, honestly, there are moments I get confused and I have to say, oh, hold on, I need to double check a few things here because of how complicated it is. I think that there could be a way of making it at least more clear than it is now that, the 10 years after this gets sealed, a couple of entities may have access to it depending on what the offense is. After 10 years beyond that, the only person who can access it is your lawyer or the state if there's a legitimate law enforcement reason. And you have to have good cause and go to a judge and say, here's why, because we think there's evidence of a cold case, or there's evidence that this is part of a massive, criminal conspiracy or a criminal organization. And, there's evidence in there. That's my thought.
Yeah, I just want to be careful we're not creating additional confusion by sort of telling someone, sometimes you can say this and sometimes you can't.
Mm-hmm.
I would think that once you have filed and your record has been sealed, you are under no obligation if someone says you have that's what they have sealed the record for. So
I'm all in support of that. If
without
just
judicial
wanna-
review, of
yeah.
course, but as me as an option, come on. You got a criminal record, but you can't eliminate the known. Okay, the press, common knowledge from people talking, you can't eliminate that. So it may be there, but I don't think you're under any obligation because your record's been sealed.
I would agree with that.
Landlords, all these people who are employers, whatever else. Why would you have to give it to anybody else if they don't have access to it? Unless there's a reason.
If we don't want to do the super sealing and just have it be super sealing from the start, I'm certainly not opposed to that.
I could certainly get on board with that, I think.
I would want to listen to that.
Yeah.
Coming from a,
Yeah. Yeah.
I'd want to listen to that, okay? Because I'm right off the bat, I don't really understand the superseding process. That's just seems to me as another way to.
I think that was something that we talked about last year as one potential solution where, there's sealing, just regular sealing for a certain number of years. And I think part of it was, law enforcement on the roadside could access it. Potential employers could access it for a certain number of years. But then after that certain number of years, it goes to super sealing, which is the next closest thing to expungement. So I'm not opposed to just having it be super sealing from the beginning and just calling it sealing or expungement, whatever we can pick the name later.
Yeah, I want to hear from all parties as you look at that process, work on that. I'm sure there'll be varying comments.
Senator Maddox, how do you? Or are you taking it all in?
No, Senator Mihoski made my point from the other day about my biggest thing was what do you say to
who?
yeah, what do you say to who?
Yeah.
You have an officer at your window or you have run into an officer, you can say one thing, but if you're talking to your employer, you can say another thing. That was something that I was struggling to wrap my head around because if we make it easier behind the scenes, but then it makes it harder for the actual person that's records get sealed. I don't think really doing anything to help the public.
Yeah, I think, I mean, one potential solution is, also putting in statute that, if your record is sealed and 10 years later you get pulled over and you say, no, I don't have a record. That statement itself, it's not going to make you liable for false information to the police. Or if you're testifying, you're not going to be, hit with a perjury charge. So I mean, I think those are some potential workarounds to it.
Yeah, but. Like Senator Brooks was saying, law enforcement officer comes up and says, do you have a criminal record? And he has covered, he or she have knowledge of this. Why are you asking to begin with, to place yourself in a position where you would perjure yourself by denying this? With that, I don't agree with that. I mean, if the person has knowledge of, say I arrested him 2 years ago, I know that they have, why am I asking you this?
Good
Okay.
question.
I mean,
Plus,
if
they
you're,
do, like you were insinuating, okay, but
Well, this is a personal, not my own experience, but someone I know that had this exact experience.
well,
And
that's,
good question. I also wonder why they were being asked that, given that that had been expunged and it had been pretty.
knowledge, then why ask it?
I agree.
I can see a situation where somebody's asked, they have a criminal record, they say no. And they ask, well, have you ever been arrested? They say yes. They shouldn't be answering questions to get at. But,
Who's gonna ask that in a legitimate sense?
It happens.
I mean, you.
or they could say, have you ever been arrested? Yes. Okay, what have you been charged or convicted with? Nothing at all. I don't know what you're talking about.
But the point is, if they had knowledge of this, then
Yeah.
why they ask it? That was my point. That's right.
Yes, yes, I agree.
And there may be an explanation for it. I don't know what it is.
In this particular instance, it was a 19-year-old who was scared and nervous and didn't know, couldn't make the
Mhm.
logical decisions in the moment. And that is why they were talking and answering questions. That you're right, they shouldn't have been.
I think we can wrap up here in a second. Any parting thoughts, closing comments?
I'm sure it's gonna be a very difficult road, but I'm sure as usual, this committee will come to some form of a compromise, good, bad, or indifferent. The best interest of our constituents.
I agree, and knock on wood, I think we actually might be able to come to a reasonable solution for sealing and expungement, at least that reduces the workload, accomplishes the goal of the actual, idea of sealing, and